Well, hello, hello. Listen, I'm sorry you're going to hear some little bit of dog bark. My window is open over here, and I cannot actually shut the window for some reason. It's a little bit stuck. So until my husband gets home, I just have to live with it being stuck just a little bit so that he can fix it. But yes, the next door neighbor's dog barks a lot, and I just all I can do is maybe try to tune it out. I mean, I don't know, but anyway. So before we get started today on our show, let me tell you what we're going to talk about. Today we're going to talk about the case of Madison McDonald. She is a Texas mother who basically walked into the police station and said, "Hey, I've just killed my children. I took their lives because I'm protecting them because they were being abused by the family. So rather than let them grow up being abused by people, I decided to take their life for them so they didn't have to live with this." Now, this is when this happened. It's already been to trial. She's already had her appeal. She's done her appeal. And now we have the appellate brief and we have the answer as to whether her case is overturned or is she staying in prison, etc. So that is what we're talking about today. But before we get started, hang on just a second. Let me get everything in. I'm going to have to shut that door and do a couple of things so we can get going on this case. And so first thing I'm going to do is read our fair use declaration, as we should always do. For the record, I'm providing the following legal notice. Any third-party materials referenced or displayed during this broadcast, including audio, video, documents, or images, are used solely for the purpose of commentary, criticism, education, and public interest analysis. Such use is protected under Section 107 of the United States Copyright Act, commonly known as the Fair Use Act. No ownership is claimed over any copyrighted material. All rights remain with their respective copyrighted holders. The material presented here is transformative in nature, as it is accompanied by independent analysis, contextual explanation, and critical discussion relevant to the examination of true crime cases and the symptoms surrounding them. This statement is entered to ensure clarity regarding the lawful and limited nature of this use. There's our fair use. Now, let's get started on Madison McDonald. This is a particularly sad case. You will find parts of this case that's going to break your heart. You'll find parts of this case that's unbelievable. One of the things you're also going to hear about this case is the baby daddies. Both of them had realized that something wasn't exactly right, but they had children with this woman anyway. So there's a little bit more about this. This is a big situation that ended up with babies' lives being taken, and the mother was going with I'm guilty because I'm crazy. That's what it's about. So this is a Texas case. Let's get started. We'll get started on it. So the first thing we're going to talk about is Madison Montgomery herself. Who is Madison Montgomery, and how did she actually get to where she is today? That is the question. Okay, so let me go up here and we'll tell you all about Madison Montgomery. Hope you're all having a wonderful day today. It's been a day over here, that's for sure. So let me tell you about what happened yesterday, just in case you're unaware. And you're going to find that the live I did yesterday has got about 12 or 13 seconds missing now. The reason being is because of a situation with paternity court. We were talking about this lady named Oneida Romulus, and she's also a Texas mom who took the lives of her children. And she had been on a reality TV show before called Paternity Court. And what happened was neither one of the fathers that she took into the court hearing were actually the father of the baby. Now, I played a little bit of the paternity court, and we talked about it yesterday in our live, but MGM actually owns this, and they decided, they didn't want us to use any of their footage. That's fine. The problem is, that's fine. The reason why we used that footage was to discuss the fact that the baby that they talked about on that paternity court show is one of the children that the mom took the child's life. So we're going to move on and talk about Madison McDonald today. All right, so here we go. I hope you had a wonderful afternoon. Okay. So what happened was this lady, her name is Madison McDonald, she was suffering for a long time. I mean, one of her exes said, he knew she had bipolar. He knew she had problems. But she just went into the police station one afternoon and decided to go ahead and confess that she had taken both of her daughters' lives. Standing there in the police station, calling them on a little phone from the from the waiting room, she calls back to the back and she's talking. She goes, "Hey, I'm out here to turn myself in. I've just taken my children's lives. I'm sparing them from the world and the fact that somebody was abusing my children and I didn't want them to live like that." I mean, that's basically how she ends up getting arrested. And it's just a horrible story. It absolutely is a horrible story. So let's go back over here. We're going to go to Wikipedia first, and we're going to pull her up this way. And this happened in the Dallas County of Texas. Let's see, Madison. It is terrible. And, you just gotta understand, or I want to know, if you knew a woman was mentally ill and you knew she was not stable, why would you choose to have children with her? Why did you do that? Did you not think ahead? Or was it just a passion thing? And oh well, it was too late. Because let me tell you something. In today's world, there's no reason for that. I mean, I really can't judge anybody for their actions, because I'm not going to. But I just think that it could have been avoided had the daddies realized or paid attention to what they were already seeing before they decided to have children with this woman. So let's go pull her up, Madison McDonald. Let's go to Wikipedia real quick, and we'll start with Wikipedia because that's where everything starts, is the information that we do know. Here we go. Come on now, stop that. Well, if my little machine over here will quit circling and carrying on, it would be great. Okay, Google. Okay, here we go. Wikipedia. We're going to go to Wiki, Madison McDonald. Okay. This particular case is going to take a couple of shows to really get through the whole thing, because there's a whole lot to it. A whole lot to it. Anyway. Here we go. Come on now. I don't know if she's actually, there's another thing called Murderpedia where you can go out and find information on all these kind of people too. Not that one. About people who've taken the lives of other people and what happened to them, etc. But so we're going to start with the Irving mom. So this is from Dallas County. And this was back on April 19th of 2023 in Dallas County. This case the trial was not live streamed, so I cannot show you any of the live stream of the case. We can only talk about what happened in the case. A jury has found that Irving mother, Madison McDonald, guilty of capital murder. She admitted to killing her daughters, 1-year-old Lillian Mae McDonald and 6-year-old Archer Hammond. McDonald remained stoic as she was sentenced to life in prison without the possibility of parole. Family members in the gallery, however, were quietly crying and just wiping away their tears. Her trial began April the 12th. In April 2021, McDonald walked into the lobby of the Irving Police Department and then called and said she had sedated her daughters, tucked them into the bed, and smothered them. Trigger warning, baby. Trigger warning. This is trigger warning, okay? Spokesperson for the department, Robert Reeves, told CBS News Texas, at the time, McDonald's demeanor was calm as she alleged her children were being abused and she would do anything to protect her daughters, including eliminating them. Okay. Day 2 of the testimony turned emotional, according to CBS Texas reporter Robbie Owens, who said the girl's father took the stand. I remember the time I got the call very early on Monday morning from her mother, telling me that she had killed the girls, said Archer's father. Now, Tim Hammond told jurors that he believed that the 30-year-old mother of his children was a good mom and that he had never worried about Archer's safety while with her. Then, in the fall of 2020, McDonald was involuntarily hospitalized to receive treatment for her mental health struggles. Hammond testified that he began to notice that she was becoming more paranoid and began to claim that the girls were being abused. Police and Child Protective Services investigated, but never substantiated those claims. McDonald's also made accusations against Lillian's father, Christopher McDonald, who told the jurors that when the paramedics hit, his relationship with his child's mother was strained and she acted more delusional. Okay. I was accused of sexually assaulting her in the middle of the night, crawling through the ceiling or something, said McDonald. She was making accusations against her mom, Archer's dad, and lots of stuff. Defense attorneys blame mental illness for the children's deaths, and McDonald entered a plea of not guilty by reason of insanity, which is the same thing that Letitia Stouch did. Now, you got to ask yourself, well, now if they have if they said, okay, I'm guilty by reason of insanity, what are they appealing? Which is the same situation we kind of have with the Letitia Stouch, because in Letitia Stouch's case, she changed her plea to not guilty by reason of insanity. That she had the trial. She was sent to prison because they decided no, she was sane, and then she, of course, filed an appeal based on the fact that one of the juror members, was somehow related to somebody that worked in the district attorney's office. Now, what this lady's appealing about, I'm not gonna get into that today. We'll talk about that tomorrow, because this has to be a two-part series, because there is so much to this case. So many different things have happened in this case. Let me go over here, and we're going to look at, let me pull up YouTube, and we're going to watch her as she has her interview with the police and talks about what happened that day. So just a second, let me pull this up. Hang on a second, guys. Come on, YouTube, let's go. Okay, so it is Madison McDonald. Oops. Hang on. Interview. I wish that dog would quit that barking, because it is driving me insane. So let's go on down to this. This is the Madison this is from a couple of years ago. And let me go to, this is the police interview right here. So hold on, this is going to be full credit to Fox 4. It's only like 3 minutes, because that's all they've released of it, I guess. Now, let me share my screen so you can see it right here. Share our screen. Okay. Now, Fox 4. Okay. This is full credit Fox 4, and here we go. Oh, I got to turn it up. Hang on. Whoops. Let me get the sound going here. There.
Police that she killed her 2 young daughters.
Much of that final testimony focused on the police interview conducted the day after Madison McDonald killed her daughters in April of 2021. In it, she continues making claims she killed them to protect them from abuse. Her lawyer argues she was having a severe mental health episode and did not know what she was doing. Fox 4's Stephen Dial, live tonight with more on today's testimony. Stephen.
Today we learned how Madison McDonald sedated her children. She told investigators that she put pills in their yogurt. Now today, her defense team says that she was off of her mental health.
I muted my mic so you wouldn't hear those dogs barking. So she puts the pills in the yogurt and then feeds it to the children. That's awful. Now, these were little babies. I mean, one was a year old. It's so horrible. Here we go. We'll keep watching them. Makes me sick, y'all.
Medication, and they presented a line of false claims that she repeatedly made to the Irving Police Department.
I felt like I did what I had to do to protect my kids. It's not what I wanted to do. I'm not okay. I don't think it's right. I think I do deserve to be arrested.
Friday, prosecutors.
Listen to what she just said. She knows what she did. She knows she needs to be arrested for what she did. I mean, I can't. It's so hard for me to understand how a mother could go over there on a child that's sound asleep because you've over medicated them and put a pillow over their head and just take their life, and then calmly leave them there and drive yourself to the police station. Does this, I mean, it seems mentally ill, right? It does, but it also seems like, just matter of fact, that's what she chose to do that day. It's a very confusing story. Here we go.
Wrapped up their case in the capital murder trial for Madison McDonald, the Irving mother who confessed in 2021 to killing her 1.5-year-old daughter Lillian and her 6-year-old daughter Archer. Much of Friday's testimony focused on the police interview conducted one day after the murders.
I gave them some pills, and Archer went to sleep, and Lillian didn't. She just kept going. So I thought that was odd, because she's a baby, essentially, so it should have, affected her heavier. It's just so hard to say. I'm calling for a lot.
McDonald told police she killed them to, quote, protect them from abuse. She told police that she gave the girls Xanax and other pills in their yogurt. She says she smothered her youngest child around 1:30 in the afternoon on April 12, 2021. and killed her oldest daughter about 7 hours later.
I didn't have tears because
So one child is deceased, and 7 hours later, she successfully takes the other child's life. So one child is laying in the bed deceased, the other one's laying there. I guess I don't know if the other child knew the child next to her was deceased or not. This is just horrific, and it's trigger warning. Okay, horrific.
I'm sad for this. I missed it already.
Oh
But
God.
I'm not sad for saving them. How long have you been planning that? It's not that I have been planning it, it's that I knew, or you wanted to protect them. How long have you thought about saving them? Well, I've been fighting to protect and save them for like a year.
When the prosecution rested its case,
Did you hear that? Oh, I've been planning on protecting them for about a year. Well, the one baby was only about a year old, so this is so premeditated. Oh Lord, help her.
the defense called up several Irving police officers. They gave testimony about 3 incidents where
Lord.
a woman fitting the same description as McDonald made false claims that her children were in danger.
We got a call that they received a note from a lady that drove through the drive-through and passed a note that said, "Call the FBI. There's a woman and 2 children in danger."
Her lawyer is trying to prove that she's not guilty by reason of insanity. They've argued that she suffered from bipolar disorder and schizophrenia, and that she was off her medications. Throughout the trial, they've worked to establish a pattern that she was not in her right mind.
Because this thing that she believed was true and had been happening for over a year was causing her daughters to be in harm.
Correct.
But it wasn't true.
It was not.
And she believed it.
She did.
It's terrible.
Week 2 of the trial will resume on Monday morning.
Okay, so we're going to turn that off. So we'll talk about this for just a second. So, I mean, she's clearly, if you're going to drive through a police department and put something in a window that says, "Please call the FBI, a woman, her 2 children in danger." I mean, maybe she is mentally ill. Maybe there's, we might find that as we go through this case, because it's a lot of information, that she truly is mentally ill. I mean, how do you, what's hard for me to understand about these people is how do they successfully navigate the world every day when they are this mentally ill? Clearly, she is mentally ill based on what we see right here. So let's go on back over here. Hang on, guys. And we're going to go back down to
The murder trial.
this is from 4 years ago, and this is from CBS Texas. So hang on just a second. We're going to listen to this one.
Heartbreaking murder investigation playing out now in Irving. Police say a woman has confessed to killing her 2 young daughters. Our Brooke Rogers live at Irving Police Headquarters right now with more details. Brooke.
Steve, police say it was around 10 o'clock last night. She very calmly walked through these doors of the Irving Police Department, picked up the phone, and told the dispatchers that she had killed her 2 young children. She told police that she had smothered 1-year-old Lillian Mae McDonald and 6-year-old Archer Hammond. Irving officers came out to the lobby and to talk to her, and then sent police to the Anthem Apartments in the 700 block of Cowboys Parkway. There, police, along with assistance from Irving Fire, found the bodies of the 2 little girls. The mother, Madison McDonald, was arrested and charged with 2 counts of capital murder of a person under 10 years of age. We do know that the girls have different fathers, neither of whom live with them at the apartment. Irving police say while the investigation is still in its early stages, they're trying to determine a motive.
In a situation like this, this is obviously a horrific incident where 2 children were murdered. We may not ever know the why, right? Because there's not going to be a definition or a reason that would ever justify the murder of 2 small children.
We don't understand.
And Irving is currently McDonald is currently at the Irving jail with no bond. She's expected to be transferred to the Dallas County Jail sometime either today or tomorrow. Live in Irving, Brooke Rogers, CBS 11 News.
All right, now I wanted to go back and find. Hang on just a second, guys. Nope. Let's see.
To me, I'm here for everybody. To me.
Okay, now let's go back over here. And this is actually Diamond Mind. Wait a minute a second. So this is coming from Diamond Mind, and I believe that this may be somebody who is. Hang on just a second. Let's just watch this because I'm not sure why this person is talking, but this is from Diamond Mind. So let's just play this with full credit to Diamond Mind. All right, here we go. Make sure you can hear it okay.
Texas, known for its seemingly endless highway of Southern hospitality, is for many a topic of conversation one way or another. There's just about something for everyone. Cities, small communities throughout, generations of farming, deeply rooted religion, emerging tech companies, more barbecue than one can imagine. And of course, you've guessed it, a famous football team.
What's this got to do with
taking
Madison?
place?
Stations and
Oh, this is from the police station, guys. This is from the police station. Does it do that right here? Hope you can hear it okay. I'm so sorry about
Monday,
the low.
April 5th, 2021 at approximately 10
You can turn it
p.m.
up.
Madison
Yeah.
McDonald had entered the lobby of the Irving Police Department to use the phone to report a crime.
And who was murdered? My children. Murdered when? Today. Murdered where and what city? Irving. And who murdered them? And how many children? How many children do you have? I have two. I have two. Okay. Okay, you have 2 kids? Yes, okay. Who murdered them?
Police were dispatched to the Anthem apartments to investigate. What officers discovered that morning would certainly send chills through the Lone Star State like a tornado. Investigators are among the first to witness the dark corners of the human mind as they unfold
I'm
the
going to skip
heinousness
past
of a
part of this
suspect's
because it's
decision.
I think part of this is AI generated. And I really just want to get to the meat of it, which is her just why she
I did what I had to do to protect my kids. It was not what I wanted to do. I'm not okay. I don't think it's right. I think I do deserve to hear what I did. What is the fastest and easiest way that I could just relieve them of this pain so they don't have to I would say peace.
relieve them of the pain or relieve yourself of some sort of a pain. See, I mean, she's dangerous, and nobody noticed how far she was getting, how way too far she was going with this. Here we go.
Of evidence to give you now. What I have is what I've seen and what I feel.
Officer Robert Reeves, I'm the Public Information Officer for the Irving Police Department, here to brief everybody about the arrest of capital murder.
Social media was in a frenzy with people who knew her putting the pieces together.
Oh, wow.
Even saying that the events could be a result of a toxic relationship with her ex Christopher. Leading the barrage of posts was Madison's longtime friend Stephanie, who also gave an interview. Stephanie said Madison was even the godmother of her children before having children of her own. Facebook post. Stephanie Washington.
I mean, we're going to let this play through because I'm not going to go to Facebook and pull this up. You know, I really don't do Facebook, and I don't really like to go over to Facebook. And if these were not on here, we would be going to Facebook. But let's go ahead and listen to this and talk about what her friends realized and when her friends realized that she may have had a problem. Here we go.
Could have reached out yesterday. I cry for them babies. Although people on here don't know the full story and are so quick to make assumptions. I don't agree that any child should ever be hurt. I just want to talk to you and find out why. I knew what you were dealing with one of your exes. I told you if you needed me to get the girls I would. I honestly believe something else was going on, or you were made to believe you did this.
She had a mental health Facebook group that she added a lot of us in from high school. And, you know, she was the one that always said, you know, if y'all need anything, reach out. Don't do anything. Just reach out to me. I'm here for everybody.
Creasa Mason, a pre-kindergarten teacher, posted. I personally knew the oldest daughter because she was in my class when she was 3. She was the sweetest. This absolutely breaks my heart. With a taped confession, the state had what it needed to set the tone for an indictment. Wednesday, April 12, 2023.
So let me get this straight. She runs a Facebook group where she's telling people, if you need help, before you do anything, before you make decisions or do something drastic, reach out. But she didn't reach out to anybody. She just did what she did. I mean, it doesn't even make any sense, really. I mean, there really is something going on with this woman. Let's try to figure out what it is. Wow.
Trial began. The definition of insanity is commonly known as doing the same things while expecting different results, but insanity in the eyes of the court of law differs. In Texas, the defense must raise the argument early in the process by submitting a motion 20 days prior to the trial date. The defense in McDonald's case did just that, setting the tone for opposing experts. Timothy Hammond, father of her oldest daughter, Archer Hammond 6, testified he was informed by Madison's mother of the tragedy. He stated that he knew Madison suffered with mental health issues when they first met. Hammond was asked of his thoughts when he was informed of the tragedy.
Disbelief. I don't know. It didn't seem real. It didn't seem real.
Julie Kidd.
You know, I can see him having a really hard time answering these questions. Now he's also the one that said he knew that when he first met with her, she did have bipolar. He knew that about her already, but he really did not realize that she was dangerous to these children. And I can see where somebody, I can see where that could happen. But there's also some discussion that maybe she was off of her medications, but I don't know that to be a fact yet, because I'm kind of watching all of this kind of cold, just like you guys are, because I wanted to be real about this. I didn't want to have a preconceived I didn't want to have any kind of preconceived thoughts about her. I just wanted to find out and go and watch cold with you guys, and we'll make our decisions together. I think that's the better way to do this. We'll keep going.
Madison McDonald's mother and grandmother of the victims took the stand in her daughter's defense.
In those last several months, she frequently believed that she did not have a diagnosis, but we had concocted all of this.
Kidd testified under oath that Madison, at the age of 13, contemplated suicide.
Okay.
Madison's counsel asked Kidd her opinion of her daughter's parenting.
She was a good mom. She loved those girls.
You did everything you possibly could for her.
Yes, I mean, you can't go through something like this and not wonder if you should have done something else.
In an attempt to argue legal insanity, the defense pointed out that Madison was documented having several run-ins with authorities and CPS for matters associated with her sanity, even presenting a bizarre post-it note presented at a drive-through restaurant in an attempt to alert the FBI.
So something had been going on with her for quite a while. I mean, you know, and again, have you ever noticed there's like this thing that happens in all of these cases that CPS has been involved in all these cases? Or I'm going to say in 90% of these cases, there's a CPS call at least once prior to these children's lives being taken. Here we go.
Expert opinion would in matters like these help paint a picture in the eyes of science. A forensic psychiatrist was called in McDonald's favor.
She was very focused on her paranoid delusions about conspiracy by family, including her ex-husband, her mother, Irving police, about her children being, her two daughters being sexually molested and participating in child porn.
She also mentioned she felt all of this could have been avoided once CPS was aware of her mental state. The concern was how could her sanity be questioned when sloppy policing was evident. The leading detective was called to the stand.
Reason we don't know that, whether she was taking her medications or not, is a failure of your investigation.
Correct.
Madison wedded Christopher McDonald.
He just admitted that due to their failure, they don't know whether she was taking her medication or not. Now that's quite amazing because usually police officers do not admit to their failures. Well, kudos to him. He deserves a hand. Here we go.
On January
Wow.
7, 2019, and was seemingly in marital bliss. Shortly afterwards, the couple welcomed the birth of their youngest daughter Lillian Mae
Oh, how
McDonald on May
pretty.
15,
Aw.
2019.
That's sad.
Christopher testified that things took a turn for the worse during the start of the COVID-19 outbreak, claiming Madison accused him of sexually assaulting their daughter during the middle of the night, and even crawling through the ceiling or something, he added. Madison, enraged, quickly sprung into action and filed for divorce. Suddenly, in a whirlwind after filing,
Dang.
Madison changed her mind with concerns of Christopher seeing other women and became very jealous. Madison was admitted into a mental facility against her will for treatment. During this time, Christopher had custody of Lillian. During the trial, he was asked why he returned his daughter to Madison.
Yes.
And as a father, I thought I was doing a good thing to let Lillian go back so she could live with Archer. And, you know, because I just thought that if I kept Lillian away, it would tear Archer apart.
McDonald's defense argued that Madison was suffering from bipolar.
See, I don't know if that's a good enough reason to send your daughter back to where you know she's not safe. You've seen the mother accuse you of all these things. You knew she was bipolar, you knew she had problems, but you send the child back because you're concerned is how this affects the half sister of this little girl. Okay. Now I'm not going to judge him. It's not up to me, but it would seem to me like, in my opinion, I would have talked to a professional before I decided to just return the child back to her, because maybe what should have happened is Arthur should have been taken away too. Maybe that's what should have happened and all of this could have been avoided. I don't know. Let's keep watching.
Polar episodes and schizophrenia, and wasn't in her right mind at the time of the crimes
terrible.
in their attempt to persuade the courts that she wasn't liable due to being insane. The prosecution called in its own specialist to shine light on the case.
My opinion was that she was mentally ill, and I believe that the mental illness undergirded the offense. I don't think there's any doubt about that. But it did not render her to the point that she did not understand that her conduct was wrong or illegal. And therefore, my opinion was she did not meet the criteria for not guilty by reason of insanity.
The prosecution's expert witness supported her professional opinion on 13 instances where Madison proved that she was sane at the time of the offenses. Including McDonald proved she was in her right mind when she called the police to report the murders because she knew it was wrong. The state gave jurors the opportunity to witness the horrifying images officers encountered while entering the residence.
Y'all got one in here, damn it.
Jesus Christ.
Madison told investigators she loved her daughter so much that she'd eliminate them. Both sides prepared for...
Hang on a second. We're going to take this back for a second. Look at her face. Just pay really close attention to her face as she turns around and looks at the people in the courtroom. Let's see if I can get this to come back up. Take a look at her. Take a good long look. Wow. Okay. We'll keep going. This is almost over, and then we'll talk about something else that happened here.
Both sides prepared for closing arguments.
It's just awful.
No sane person could believe these things, but she believed it.
Oh, wow.
And the police believed she believed it. Her mother believed she believed it.
Find her guilty because she is guilty. And she does not meet the legal definition of insanity.
Prosecutors disagreed with claims of mental illness, quoting that the motive for the killings were retaliation to a failed relationship, pointing out that Madison filed for divorce with the couple agreeing on amicable terms. On Monday, April 5, 2021, Madison McDonald showed up at the Irving Police Department to let the world know the love of a caring and concerned mother who'd go to the depths of the world to protect her young, carrying 2 baby blankets. Prosecutors made sure to mention that Madison McDonald lured her young in by providing them with a tasty serving of poisoned yogurt, which was used to slow down their respiratory system, which followed by her smothering them with the very blankets she carried in that day.
Look at her. She's standing there in the police department, in the waiting area, as she's picking up the phone to call back and say, hey, I'm going to turn myself in. I'm going to report this. And she's got the blankets that she smothered the children with in her hands. I'm telling I thought she's mentally ill, but at this point, I'm not sure. Because to me, this seems like it's so premeditated and so, something's wrong, but I'm not sure what it is. Let's keep going. Oh my God. I did not realize that until just now.
She admitted to murdering
Damn.
Archer Hammond first, then 7 hours later doing so to 1-year-old Lillian.
Oh God.
She said she found it odd that her smaller 1-year-old receiving the same poison just kept going. That was strange, she added.
Oh
With
my.
evidence compounded from both sides, which way would the jury lean? In less than an hour the jury returned with its decision.
In less than 1 hour, they made their decision. That's how sure they were after 2 weeks of, I mean, there was a 2-week trial, but it was not televised. So there's so many parts of it that we're not going to see. Now, when we read the appeal, we're going to know all these things, but less than 1 hour. That is fast.
Having returned a verdict of guilty to the offense of murder, capital murder, is there any legal reason under law why you should not be sentenced at this time?
Life in prison without the possibility of parole, Madison stood motionless. The jury wasn't convinced. Her supporters console her mother outside the courtroom.
Wow. All right. Let me turn this off. Now, I'm going to unshare the screen. I'll go back over and start, and we'll talk about this a little more. I mean, it is a shocking story, and I'm not sure what to believe. I'm not sure whether to believe she was actually insane, not insane, because it is premeditated. We know that, and she seems so flat. I mean, I didn't see any emotion at all. I mean, no emotion. What in the world? It's hard for me to even. It's hard to imagine that somebody could stand there and just look somebody in the eye and discuss this. Okay, all right. So we're going to go back over here. We're going to talk about what happened when she decided to file her appeal in the courts. Now, the first thing I'm going to do is I'm going to show you the appeal, the oral argument. We're going to watch the oral arguments today, and then tomorrow we're going to go through the brief and discuss what happened at the end after the oral arguments and after the briefs were filed. And because there was a lot of back and forth on these briefs and the dates of the filings, I mean, it's a long list before it actually happened. So let's go pull that up really fast, and we'll watch that part. We're going to have to do part 2 tomorrow. Sprinkle will be able to come on with us tomorrow because she had to work today, so she couldn't be on with us right now. So I wanted to do part of it today and the other part tomorrow. So let me pull this up right quick. We'll get the appeals hearing, okay? Get over here to YouTube. Of course, good old trusty YouTube. Now, let me pull up Madison McDonald, her appeal oral arguments. Okay. Now, this is going to be it right here. And this was streamed 3 months ago, and it's Madison McDonald versus the state of Texas. So let me get it ready to start. And this is going to be full credit to the Texas Court of Criminal Appeals. Okay, so I'm going to have to, let me share my screen so you can watch. No, not that one. Hello. Hello. This one right here. Share the screen. These hearings are always so very interesting. They really are. All right. Now, this is the full credit to the Texas Court of Appeals. All right. Hope I'm spelling it all correctly. I don't want it to kick back at me. Sometimes, I mean, all right, there we go. Ready? Let's start listening. I'm going to try to turn it up for you. Because they don't talk very loud sometimes over here. Okay, here we go. All right. State of Texas, it's Madison versus the state of Texas on her appeal. Oh, let me put on a little screen up there so we don't get in trouble. I don't think it'll be a problem. We're going to go without it right now because we're going to have to stop and use, this is, okay, let me do this. We're using this reel right here under fair use to discuss this case. Just putting this out there under notice that this is used under fair use for commentary. Here we go. Okay, let me turn it up.
God save Texas and this honorable court.
God save Texas.
Please be seated.
Good morning, everyone. Thank you for being here today. We have one case set for oral submission today. I'm going to call that case first. It is Madison first. Madison McDonald versus State of Texas, PD 0147-25. We will hear first from counsel for the appellant. As both counsel approach the microphone, if you could do us the favor of announcing.
Looks like he's looking right at us, doesn't it?
What side you represent, that helps us keep track. Counsel, I understand that you have elected not to reserve time for rebuttal.
Yes, Your Honor.
If you end up coming up a few minutes short, that'll be fine. I'll let you have that time later if you choose to use it at that time, if that works for you.
Yes, sir.
Okay.
And I'm Michael Mola for appellant Madison McDonald.
Go ahead. Yeah. Glad to have you here, counsel.
Thank you.
Oh, not that one. Trying to add something
May
to it,
please
so we'll have an
report,
overlay.
counsel for the state. And my name is Michael Mola. I represent Madison McDonald on appeal to this case. This is an appeal from the 5th Court of Appeals on cause number 0523004119CR. My client, Ms. McDonald, was convicted of capital murder under Texas Penal Code 1903A8 for the intentional and knowing death of her daughter, AH. Now, during that transaction, as the court knows, she killed both her daughters. AH was 6. I'm going to refer to them as their initials, like in the briefing. And LM was about 18 to 20 months old. And I'm asking the court, based on the one ground before this court, to reverse the opinion of the Court of Appeals, reverse the judgment and sentence, and remand the case to the trial court for a new trial. That's the relief I'm asking.
If I can jump in here, let me see if I want to ask a couple initial questions. Justice Lee on the 5th Court dissented from the denial of rehearing in bank, and he had a pretty detailed opinion. In it, he does a chronology of the events leading up to the controversy at the time of the testimony of the expert. Is there anything that he put in there that you would think is wrong or incorrect in terms of the chronology?
I don't, Your Honor. I had filed a timeline of critical events Monday night, and I apologize for the late filing. I just thought it might help the court in its decisional process. And mine's a little more detailed, just as additional facts to Justice Lee. But I'm actually asking the court to adopt the published dissenting opinion on reconsideration on bond.
Okay.
So, yes.
Whoa. Reconsideration on bond. Okay. So now she went to trial under, I'm going to plead guilty by reason of insanity. Okay. They decided she was not insane, that she actually knew what she was doing. She gets life in prison without parole. They've been through a few appeals. They're finally back now in front of the Texas Supreme Court. And he wants to let her get a new trial, okay, based on I don't know what, and be out on bond when she's clearly a danger to herself and others. Oh, here we go. That's what's going on here. Okay, guys.
I want to sort of get focused on where it is.
Wow.
You may disagree with each other about what the facts are and anchor on what your legal argument here is. Because it seemed to me the first time the state communicated with, there's two C doctors here, that's Crawley and Compton, is it?
Dr. Compton was the state's expert,
okay. So
one that was appointed.
In Justice Lee's dissent, he starts with the state reached out to Dr. Compton for purposes of obtaining a consultation on competency. Is that right?
She actually testified, Your Honor, that she was retained to discuss both competency and insanity, and she said that during the hearing.
Okay, I think I'm with you there. I just want to make sure that initial communication said that the defense counsel had been communicated in connection with, had visited with the DA's office in connection with that initial contact to Dr. Compton, and that there was no objection from the defense counsel. Is that right?
Well, before the indictment, which was returned on June 14th, 2021, Dr. Compton was approached by the state for consultation regarding insanity and competency. Now, at the time, there's nothing in the record showing that defense counsel knew about that agreement at the time. I didn't see anything in the record showing that they knew.
Well, that's why I asked, because Justice Lee's dissent indicates that defense counsel, at least according to the record he was looking at, had been contacted and informed of the fact of that engagement with Dr. Compton. Maybe that's right, maybe that's wrong. I just want to know if that's different from your recollection, that defense counsel was aware of the fact of that initial.
I didn't see in the record, Your Honor, that he was aware of the fact before the indictment was returned. Now, sometime later, he became aware of the fact that she was contacted for competency, but I didn't see anything saying that he knew before June 14, 2021, that she was.
Okay, well, you're anchored on that date in terms of the engagement for purposes of Article 4. I can't remember the exact code number, but so the problem, as I understand it, and please correct me if I've got it wrong,
sure,
is that initial engagement was looking at more than just competence and maybe also got into insanity. And when Dr. Compton met with your client for the first time, discussed with her in the absence of counsel facts relating to the events for which she was going to subsequently be tried.
Yes, sir. She met with Ms. McDonald, Dr. Compton met with Mr. McDonald on August 20th, 2021. The suggestion of incompetency was filed by defense counsel on July 30th, 2021. And that's page 47 of the clerk's record.
Okay. And then, just so, again, I'm sorry, I think we got the dates from, we'll have your Monday filing and we've got Justice Lee's dissent. I'm just trying to get clear in my own mind where the problem begins. And you say she was not re-Mirandized by Dr. Compton at that initial communication. According to Justice Lee's dissent, defense counsel was aware of the fact that that communication was going to happen. Later, when you go to trial and are objecting to the testimony, you note that she wasn't Mirandized by Dr. Compton. Dr. Clayton, your doctor, testifies that the Fifth Amendment, as she understands it, would require a communication with the expert for purpose.
Okay, so it's kind of what this is boiling down to, just kind of a little update, because I know it gets very confusing because they're just going back and forth, back and forth. But when they have the discussion about these experts and this, and when they're basically talking to the defendant and they're talking about were they Mirandized or not, because one of the things that they say is when you're having your discussion with the expert about this incident, what you're telling them will not be held against you. This is almost like some kind of private, like it's got some confidentiality to it. But instead, what happened was they were in trial, and absolutely some of the things she says was used against her. So the question is, was it proper and improper? Has she been Mirandized again or not Mirandized again? And that's what this discussion's about, just to catch you up on that. Okay, here we go.
Of competency to not get into the details of the event, right? But that's I'll jump toward a couple of questions. That's the doctor's opinion about the Fifth Amendment, right? So I'm trying to get you to tell me where you think the Fifth Amendment problem starts in this case. Is it from that initial meeting? And if so, is it based on the doctor's failure to Mirandize, the absence of defense counsel, or the fact that she asked a question that would go into the particulars of this case?
The problem began before the indictment was returned on June 14, 2021. She was hired by the state for consultation on the insanity issue. Okay. Now,
let me just interrupt you because I have the same concern. Was she initially hired for competency purposes or for competency and insanity evaluation?
The record, Your Honor, shows both. She was first initially
by
hired
the state?
By the state for both, yes.
Okay.
Yes.
And when she was interviewed that first time or that initial process, if it overlapped into the sanity issue, was she Mirandized?
There's no evidence in the record, Your Honor, that she was Mirandized. As a matter of fact, I believe in her report, in her undated report that she had filed, and that's a State's Exhibit 168. There's some information there where she says that she told Ms. McDonald that things that she says, wouldn't be used against her in a later proceeding. Okay, so that goes the opposite of being Mirandized. So, you know, it doesn't say that I did not Mirandize her, but that comment in the report, that's a strong inference that she didn't Mirandize her.
Yeah, but that's sort of why I was getting at this recitation, at least in the dissent below, that defense counsel knew of this communication was going to happen, that this interview with Dr. Compton was going to happen. She'd already been Mirandized by the police, right?
Right.
Okay, so now she's talking to somebody that the government has sent to her, who tells her, now, okay, this is maybe an additional and different problem, but tells her it won't be used against her. But defense counsel was informed of this, according to Justice Lee's dissent, was informed of this communication and chose not to be there.
But about competency, he thought defense counsel was informed that the meeting, the examination on August 20th, 2021 was going to be about competency and not about insanity.
And okay, that gets to the legal question. I've got the distinction. You've got Estelle. What else do you have for the idea that there's going to be a communication between a state-appointed psychiatric professional and the accused? That conversation could not possibly, if it's limited to competence, get into any facts surrounding the underlying charge. You've got the testimony of Dr. Clayton, who is an expert on psychiatric practices, but she's not an expert on the law, right? And her testimony should not be taken for that purpose, right? We don't have experts on the law. The judge is the expert on the law. So what's your best case for the proposition that counsel informed of the fact that there's going to be a competency examination should rest easy and feel not obliged to attend on the notion that that conversation will not delve into any?
I know it's very, very confusing, and I understand why he's asking these questions. Because if this is your defense, and you know that this hearing is going to happen, because they all know that there's going to be a competency hearing. They all know about this, the sanity hearing. They all know this. And as a defense, if my defense attorney, I would request that they be there, okay? Because somebody needs to be almost like maintaining the integrity of this discussion so that we don't get into this information about the crime itself being used against the defendant in the middle of the trial, because that's what exactly happened in this case. Here we go.
Of the facts involved in the case.
Well, Estelle versus Smith, Your Honor, I think it's pretty clear that says the Sixth Amendment right to assist the counsel was violated because it wasn't clear that counsel had been informed about the examination. And
your counsel was, right? But you said he was informed about it, but it was about competency.
Well, and even so, counsel wasn't aware that examination would require inquiry about Smith's future dangerousness. So Smith hadn't received didn't have the opportunity to discuss with counsel about the scope of the examination. And there are other cases as well, but Estelle is the main Supreme Court case that discusses it. Bottom line is, I didn't see any record evidence showing that trial counsel, defense counsel knew that Dr. Compton was going to get into the facts of the case and issue insanity. And then, as you recall, Your Honor, later on, before she was appointed as a disinterested expert by the court based on the state's motion, she admitted both in her report and on the stand that she had already made up her mind about Miss McDonald's insanity before she even did the examination.
Okay. If that is the case, this is very, very damning. As a professional who is paid to go in and listen, talk, discuss about the sanity or the competency of the defendant, you cannot make up your mind before you go and have a discussion with them. And if you're admitting that you made up your mind before you went and had the discussion with them, this is not good. This is absolutely terrible. Okay, let's keep going. Boy, this is bad.
For insanity took place on August 3rd, 2022. And she said this in a July 27th, 2022 email. That's Defense Exhibit 17 that she had sent to the state, saying that, I don't, nothing's going to change my mind, regardless of what I hear from her. Now,
where does that anchor in your argument here, is that a due process problem, or is that a Rule 702 or 3 problem as to admissibility?
Well, the claim was a Fifth Amendment claim with regards to, her right to counsel, and, her right to have counsel present.
Okay.
So, the Fifth Amendment, it was a Fifth Amendment claim filed by
That is amazing.
trial counsel, and the argument on appeal is a Fifth Amendment claim. Her testimony should have been suppressed because it was a motion to suppress filed by trial counsel.
Yeah.
And, of course, based on the suppression, that would, effectively disqualify
I have to
her.
agree.
That's the reason for the language of disqualification language. The bottom line is, Your Honor, she was not a disinterested expert. Now, the issue 1 on the direct appeal was the sufficiency issue. That, of course, the jury had rejected it during the trial, and the Court of Appeals rejected it. I had filed that as one of the grounds for PDR. The court granted it only on this ground. But the bottom line is that when a jury is presented with an expert who's represented as a disinterested expert, and the expert is not disinterested, the question is, how much emphasis would a jury place on that expert's opinion? Because experts,
But again, what I'm struggling with is you're sort of mixing legal concepts, at least in my mind. The expert, let's say I agree with you, expert was not disinterested.
Right.
In my view, and correct me if you disagree, that's anchored in a Texas statutory provision about who can be retained as an expert. Where is that in the Fifth Amendment, and where is that in sufficiency?
Well, the 46C 103 talks about disinterested experts, okay, appointing disinterested expert for an insanity.
Actually, let's talk about what happens when jurors hear expert testimony. And this kind of goes back to, go back to the Murdaugh case, because this is in the Murdaugh case, this was kind of an issue when they talked about the expert witnesses and things like that. The jurors tend to believe the police officers and the experts before they believe the defendant or the defense attorney, because they have some preconceived notion that, well, that's an expert or that's a police officer. We have to trust them. They're going to tell the truth all the time. They're the one who knows best. That is something that happens in these jury cases. And I understand what the complaint is. And boy, here, let's keep going. This is interesting.
And the remedy for a violation of that is what?
Well, what happened here is that a expert that was not disinterested went and interviewed Miss McDonald without counsel present.
I'm with, okay, so, yeah, but.
So that's where the Fifth Amendment violation. So the argument isn't that you should reverse simply because she was disinterested. She was not disinterested. Right. That she was an interested expert. The argument is that
so it's sort of an atmospheric loss on your due process problem of the initial interview was done beyond the reasonable scope of the consent of counsel, getting into insanity, and then you have the statutory problem of the expert is not disinterested. But even if the trial court has erred in the qualifications of the expert, is the evidence available for the jury to consider from purposes of against a great weight and preponderance?
Well, not erred on the qualifications of the expert. There's no argument Dr. Compton is a qualified expert. Now, erred on whether she was disinterested. The fact that she was not disinterested is why Fifth Amendment violation occurred.
But if I remember the Court of Appeals panel opinion correctly, it indicates that opinion from Dr. Compton, let's assume she was disqualified by a combination of the manner in which she had the initial conversation and the fact of her apparently being not disinterested for purposes of the statutory prohibition. The panel said there's more than enough evidence without that testimony. So if we take your sufficiency challenge, take out the expert opinion, there was more than enough evidence before the jury to reject her insanity argument. Now, you and I know that there's obvious there would appear to be mental health issues involved, hence the initial engagement of but the standard for insanity to avoid legal culpability is high. Yes.
Yes, Your Honor, it is.
But how do you answer the Court of Appeals panel decision that the jury didn't need Dr. Compton's testimony and the result would have been the same?
Yes, sir. On pages 20 to 23 in my brief, I set out 23 well-cited in the record factual assertions showing why she was insane at the time.
We will be reading the appellate's brief tomorrow, all pages of it. It's a very long brief, but I wanted to have sprinkled on with us when we did that. So today we're hearing this part. Tomorrow we'll get into the actual brief itself.
When we take a step back, it's my argument that no sane mother protects her children against serious harm that she believes to be real by killing them. So, you know, when she went, presented herself, do you recall?
I know, but you and I are now having the conversation on the back of a bus that regular people would understand. This is nutty. Mothers don't kill their children.
Right.
But going back to England in the 1700s, we've developed a standard for when people are legally responsible for their conduct. And it is not, this is nutty.
Right.
It is, I understood basically that this was wrong. Right. And that you had to, for purposes of sufficiency, you had to show no reasonable juror or the great weight and preponderance of the evidence for this purposes was against any conclusion a jury could have gotten to that she would have understood that what she was doing was wrong.
Well, she, during her interrogation or it was an interview with Detective Mayorgas, the Irving Police Department, she effectively said, you know, I'm paraphrasing because it was a long interview, that she did what she did to protect her children from, you know, this, you know, child trafficking, child sex conspiracy that she thought existed. And, you know, anyone who disagreed with her, police, whoever, her parent, her mother, the father of the girls was also part of the conspiracy. You know, so in her mind, she committed this horrible act thinking that she's protecting her daughters. So, you know, that's not just nutty, Your Honor, that's insanity.
Counsel, let me ask you a question.
Yes, sir.
Why doesn't the bringing of her own mental health testimony, for instance, the idea of a Legrand waiver,
Interesting.
why does that not resolve any Fifth Amendment problems in this case?
Well, because again, the initial issue was simply competency. It was, you know, a suggestion.
But your argument here to this court is that this is effectively a Fifth Amendment violation.
It's a Fifth Amendment violation.
Okay, so if the witness here constructively testifies through bringing their psychological expert to testify as to mental health and insanity, how is that not a waiver of their Fifth Amendment right under Legrand?
Because Dr. Compton was presented as a disinterested expert to the jury.
Well, Dr. Compton was presented as a state retained expert on the competency, but the actual testimony at trial was, okay, sometime after that, you were appointed by the court to conduct an insanity evaluation. So that part is neutral, but before that it was, you have been retained by the state, correct?
But so, right. But again, initially she was retained by the state for both insanity and competency. She's a state expert. I've never seen a situation where a person went from being an expert for the party to a disinterested expert appointed by the court.
Let me try it a different way.
Okay.
If this expert, Compton, had been called by the state
yes,
as a state's witness,
yes,
not as an independently appointed court, you would concede that by calling their own witness to testify as to insanity, they then allow the state to bring in testimony and do their own evaluation of the defendant and testify as to the results of that evaluation. They effectively waive that Fifth Amendment privilege under Legrand, at least to a limited extent, correct?
only if it was represented initially that she is a state expert.
Then let me ask you this. If that's your position, then isn't the harm analysis, if we ever get there, isn't it that there was one retained witness on one side, one retained witness on the other side, and the jury simply didn't get a third neutral? It isn't so much that Compton testified, it's that there wasn't a...
Yeah, I think I understand. I agree with him right there, because I think that is the point that the defense attorney is trying to make over here, that, well, they were not disinterested. So we have one of each, but nothing in the middle, no neutral person. So I think this justice has exactly right. And I think that it's going to be interesting to see if this defense attorney can rebuttal back with him about, whether he has it right or wrong in his mind, because he cannot, it's like he's having a hard time explaining what he's trying to say happened here. Here we go. Let's listen.
Third, court appointed neutral, because the state would have been able to call Compton as their witness once the defendant brought their own witness on insanity, right?
But that's not what the state did, though, Your Honor. The state presented Dr. Compton as a disinterested expert. Okay, she went in for a competency examination, and it's true that Dr. Clayton's opinion is not a legal opinion, but I've never seen a competency report have all the details of the offense. She went in as a state expert to examine Miss McDonald for competency only, and she got into things other than competency, mainly the issues of the offense, the facts of the offense. And then
still having problems with this Fifth Amendment issue. The defendant put insanity squarely at issue by pleading an insanity defense. Under our previous case law, principally Legrand, but extended through Paulron and Chamberlain, that means there's at least some limited waiver of the Fifth Amendment rights. It is constructively testified. Waiver. If you're focusing this on Fifth Amendment, you've got to explain for me how I get past that.
There's a waiver only if it's presented to defense counsel, because she was retained by counsel, or she had an appointed attorney at trial. If it's presented to him that Dr. Compton's going to be going in, or whoever is going to be going in to examine her, is for the purposes as a state witness, the state expert, excuse me.
Well, your point is that the horse is already out of the barn door by the time he's had the initial investigation.
The horse is already down the street, Your Honor, running down the street. Yes.
Okay, counsel, so your light is on. I think you have 1 minute left if you
Oh,
want to
boy.
use it later.
Okay.
All right, thank you.
All right,
I guess he's going to revisit on that one. Okay, now it's time for the state.
Morning. May it please the court. My name is Jacqueline O'Connor Lambert, and I represent the state of Texas, Dallas County, in this appeal from Madison McDonald's conviction for capital murder. Now, in this proceeding, we have it's been framed as one issue, but the reality is there are two very distinct issues before this court. The overarching issue is, did the trial court err by admitting Dr. Compton's testimony in this case? But really, there's two distinct arguments. One argument is that she shouldn't have been appointed under 46C. And that's not an evidentiary objection. That's just an objection to the trial court's appointment order appointing Dr. Compton. The other is the Fifth Amendment claim, and that is an evidentiary objection. I'd like to start by talking about a few of the questions that were explored by appellant's counsel on direct appeal. I believe one of the questions was about the dissent and about the chronology that was outlined in that. I would say that it was mostly accurate. There's a few things that I would point out that were incorrect. One of them is that the dissent takes issue with when the defense actually was on notice that we were going to call Dr. Compton as an expert. And I believe that the record is clear that was developed at the hearing, that the minute that Dr. Compton issued her insanity report, that was forwarded to the defense, and the parties knew at that point that we were going to trial and that the issue was going to be insanity. And that was 8 months prior to trial. That was always going to be the issue in this case. So when we sent that report from Dr. Compton to the defense, at that point, everyone said, all right, let's set a trial date. We're going to trial, and the issue is going to be insanity. So this idea that they were surprised or they didn't know up until the point of trial is just not true. Additionally, the dissent talks about how she was not properly admonished before the competency exam, and that is also untrue. In Dr. Compton's competency report, she talks about that she gave the relevant admonitions that are required under the statute. And there's two statutes that are really important as it relates to competency. The first statute is 46B.024, and that is the statute that outlines the factors that a doctor is to consider when they do a competency evaluation. And in that statute, one of the factors is the pertinent facts of the offense and the defendant's state of mind at the time of the offense. So this concept that she was not allowed to talk to Madison McDonald about the offense or about her state of mind is just not true.
That helps you, but maybe it hurts you too. Because I think Justice Lee starts that dissent. That's why I want to start with that chronology with defense counsel was informed of the fact, and I think counsel opposite has agreed with that this communication was going to happen between Dr. Compton and his client.
Yes, and they agreed to that.
But, and as you pointed out, the statute says with respect to competency, she may get into that subject matter. Where was defense counsel informed, and when was they informed that she would also be an expert on insanity?
Specific,
Obviously not then, because the issue hadn't been raised.
the issue
by
had not been raised by the
by
defense
by the
yet.
defense counsel.
Correct.
But if the state intends to use her for that purpose, aren't you running the risk, if you are going to get into the subject matter of the events, not informing counsel opposite that this witness may potentially be a subject matter expert on mens rea, guilt or innocence at trial?
Well, I
So the
think,
defense counsel has an informed basis to decide whether he wants to attend, to document the fact that these admonishments were given at the beginning of the inquiry. Because right now we're going off of Dr. Compton's notes, right?
it's actually in her report on the first page that she gives the admonition.
Oh, wait a minute, counsel, and I may be missing it, but it says on that report, if I'm reading it right, any statements made during the course of a competency examination could not be used against her.
That's correct.
That's
So
correct.
what you're talking about is,
Could not be used against her. But remember, though, they're in the trial, and the same doctor has said she'd already made up her mind as to whether that she was competent or not competent. But I can see the problem here, and I'm afraid it might cause her to get a new trial. I hope not. I hope not. But you cannot have a doctor who's supposed to go in there and make a decision based on what she's told after interviewing this person. You cannot have the doctor cannot have already made up their mind before they ever even talk to the person. That is the same as having a juror who's already decided that she's guilty before she's even heard any testimony. It's the same level. So here we go.
that she was given a Miranda warning?
So the
Where do I
statute,
find that?
46B.007 is actually the statutory provision that protects a defendant's Fifth Amendment rights as it relates to competency.
Well, there's a 46B00 at the back of this, but it's pretty, I mean, just to be clear, you're expecting a lay person to understand fully the implications of this. Admissibility of statements and certain other evidence, a statement made by a defendant during an examination or trial on Mrs. McDonald's incompetency, the testimony of an expert based on that statement, and evidence obtained as a result of that statement may not be admitted in evidence against Ms. McDonald in any criminal proceeding other than at a trial on Ms. McDonald's incompetence or any proceeding in which Ms. McDonald first introduces into evidence a statement, testimony, or evidence described by this article. You think a layperson who has serious mental illness should be able to extrapolate from that to an effective Miranda warning?
I'm assuming that her attorneys discussed that with you because it is, we discussed that with her because it is the statutory provision that governs and protects her Fifth Amendment rights.
Was
And
she
then
given this report? I mean, obviously not at the time of the evaluation.
was Madison McDonald given the report?
But this report was created as a result of that evaluation.
Correct.
So it couldn't have been in existence when she did the evaluation.
No, but the defense knew that Dr. Compton was going in to do the competency eval. So I'm assuming that they discussed all the
But what I
relevant-
heard you said was that this report had evidence in it that Dr. Compton effectively gave her those warnings, and I want to see it.
Oh, on the first page of the report, she lists the informed consent on the very first page. And she says that she informed her that a finding of incompetency neither hurt nor helped her case, and that any statements made during the course of the competency could not be used against her. And then she cites the article. And so in her testimony, she said she explained the admonitions to her and that what Article 46B.
I get that helps you with the statutory issue. But you're treating the statute as a sunset on the Fifth Amendment. It doesn't work that way. It's the other way around, right? And this statute could have protected her for purposes of competency, but having chosen that lane for this testimony and potentially misled the accused, who's already, you've got to be more, this is a sensitive setting, right? You've got someone with known mental health issues that your person is talking to without counsel present on the basis of a statutory representation, which is repeated in live, that nothing that is said here is going to be used against you at trial. Why haven't you poured concrete around the feet of your expert into the lane of competency, but not insanity at trial? Because you've told her nothing you say here is going to be used against you at trial.
Why have we not instructed Compton that she needs to 100%?
Well, I don't care.
Why is that not dispositive on the Fifth Amendment?
If defense counsel objects to her showing up and saying, now I'm going to talk to the jury at a guilt or innocence phase about whether she's guilty based on what she told me during what was supposed to be a competency evaluation, where she was assured this was not going to be used against her at trial.
Well, she was assured that it could only be used against her under certain circumstances, and those certain circumstances happened at her trial. That statute says that it can be used against you if the evidence is first brought up by the defense, which is exactly what happened in this case.
Well, that's the point of Justice Kennedy's opinion with respect to waiver of the Fifth Amendment, which Judge Finley was asking.
Yeah, and that's what I wanted to get. I mean, obviously there has to be harm here, so let's talk about harm. And I mean, the hypothetical in my mind is the judge says, okay, Dr. Compton, you can't testify. The defense puts up whatever it puts up, and then in rebuttal, if there's contradictory statements that she made to somebody else, they get to call Dr. Compton back, right, and say, well, didn't she actually tell you this? I mean, assuming it's a Miranda and Fifth Amendment aside, as long as it's a voluntary statement, you can use those to impeach him.
Yes, correct. And there's no evidence that the statement was involuntary. Ms. McDonald participated in these proceedings throughout. She was very cooperative with both sides, and there's no issue of voluntariness with any of the evaluations that were done. And I agree with that 100%.
Yeah, she participated with the knowledge that this would not be used against her. That is the, I'm sorry, and I'm usually, in the middle here, but it seems to me like the defense may have a real argument here. We'll keep listening, but I think he might have.
That once the defense presented the evidence through their expert, that opened the door to all of that evidence. There was a waiver of the Fifth Amendment right then and there. The statute allows for it and the case law allows for it, because even if it was illegally obtained, it could have been used for impeachment. And then under the statute.
Well, when you said could have, just to be clear, I may have got the facts wrong. But all of Dr. Compton's testimony in this case as to insanity was rebuttal testimony, correct?
Correct.
Okay, just to be clear.
And also to be clear about that, when the state presented Dr. Compton during the case in chief or during the rebuttal, we did not elicit any information from her about any of the contents of the competency interview. That was done on cross-examination by the defense.
But you knew she had that information.
We believe that all the information she obtained at the time of competency was pursuant to the factors outlined in the statute. We did not believe that there was any information that was illegally obtained at the time of the competency interview. She's allowed to ask about all of those
That's
things.
the question.
The real question is, how is she allowed to use them later? And I think that's the real question in this case, is how are they, they're going to learn things during a competency interview, and what are they supposed to do with that information? They can ask the same questions again during the insanity. If we want to wall off competency, they could then ask the exact same question.
This is sort of like they could ask the same questions, all right? But here, this is kind of like a reverse Miranda. They didn't go to her and say, anything you say can and will be used against you. They went to her and said, nothing you say can or will be used against you. And she then answered her questions. Yeah, later she could come back and say, now we're doing the insanity phase. Oh yeah, everything you say can and will be used against you. But to try to merge those when in the one you have a mentally ill woman, at least by the defense's assertions, who may not have a full understanding of this. You have a really fairly complicated extrapolation from some fairly obscure statutes, and you literally have a reverse Miranda situation. Stage one, competency, nothing you say can be used against you. Stage two, insanity, she could have used the same questions, but it would have been under the, everything you say can be used against you. And you're arguing to us that it doesn't matter. She was sufficiently warned, and therefore, we didn't put that in. We just put her up so the defense would. That's hard to get around.
I think that, well, for one, I don't think there was any nefarious intent. I think Dr. Compton was just trying to follow the statute, because that's the guiding principle that she has when she conducts the exam. I think also that, again, there's this waiver principle that anything comes in once the defense presents the evidence. And so I'm assuming that—
Isn't that why the defense can have their interested witness, the state can have their interested rebuttal witness, and the court under this statute, which is what this expert was appointed under, may appoint a disinterested witness specifically to avoid that problem. Isn't that the reason for that statute?
I think the reason for the appointment statute is because the trial court has to make a preliminary determination of whether the issue of insanity should go to the jury at all. And so the statute allows the trial court to appoint an expert to advise them on whether there's actually an issue of insanity.
And that expert tells the defendant that nothing they say in that competency can be used against them.
Nothing can be used against them except under certain circumstances. So, I mean, that's the caveat. I'm not trying to parse words. I just think that that's important because they're being told it can't be used against you unless, and then there's two circumstances of when it can be used against them: in a competency trial, and then if the defense brings it up first. And the latter is what happened in this case.
I mean, I feel like that's where we're stuck because in a normal Miranda problem, the defense can maneuver around. Like, so if a statement is illegally obtained, the defense can maneuver around that so that statement never comes in. But in the mental health context, we're stuck because it's always, I mean, it feels like, and maybe I'm putting words in your mouth or maybe I'm wrong or both, but like, I mean, it feels like we're stuck no matter what because we're in a mental health context. Because anything she says to a mental health professional by definition is almost going to come out regardless. I mean, can you comment on that?
I would agree with that. I mean, I think the case law is clear that the constructive waiver actually happens when they talk to their own expert. And so there's this sort of like concept of waiver. When they talk to their own expert, when they break their silence and speak to their own expert about whatever mental health issue it is, whether it's insanity, competency.
Just so I'm clear then, if I'm a defense attorney and I get a mental health expert to talk to my client for purposes of evaluating whether I can assert an insanity defense, and I don't call that expert at trial, you're telling me that that is an effective waiver of the client's Fifth Amendment, right?
You talk about testifying.
No.
That's what I'm saying.
Right.
Testify.
Not
But it's
until
not when she talks to the expert, it's when
there's
the
a-
expert testifies.
The case law says, Legrone and his progeny says that the constructive waiver happens at the time of the interview, but the evidence doesn't become admissible until the defense offers it first, and then the state can put in the rebuttal. And so going back to your question, I think that, yes, in a mental health context, that is a risk that you take when you want to raise a defense of insanity, is like you're basically allowing your client to be interviewed by a court's expert or a state's expert, but in the interest of potentially having favorable evidence come out of that, right?
But you have the right to have counsel.
Whoa.
Right? During that interview.
In my practice, I don't know that attorneys attend any of these
But
evaluations.
do they not have the right if they want?
They have the right to consult with the attorney before or after, but they don't typically go. So
What are your thoughts on Satterwhite out of the Supreme Court in the late 80s that talks about interviewing defendants and the facts of the case?
I'm not familiar with that case, Your Honor. I apologize. If you give me a little bit of the facts,
Pretty much what we're talking about.
Okay.
And that is that the expert went in, talked to the defendant, got admissions about how the crime was committed. The lawyer didn't know about it and subsequently used that testimony in the case in chief and in the punishment phase. It was a death penalty case, but the legal issue is still the same.
okay. I think the distinction between that case and ours, which is very similar to Estelle and ours, the distinction is that one, the defense attorneys knew in this case about both evaluations ahead of time. So they had the ability to consult with their client prior to that. Secondly, she was given admonitions prior to both evaluations. That didn't happen in Satterwhite or Estelle. And then third is the waiver concept, that if that had occurred, if the defense didn't put on any evidence, that would not be admissible.
But I guess my only concern is if the defense attorney thinks that his client is being interviewed strictly for purposes of competency and not sanity, he's kind of at a disadvantage.
I would
Because the
agree with
competency
that.
would just strictly go to, can he be tried or not? The sanity is just, it's a defense that they're using, right?
And I think that's where we disagree about, I think Appellant and I disagree about what occurred at the competency, because I believe that Dr. Compton was following the statute as she's supposed to do. And the defense has characterized that as she went outside of the information that she should have obtained during that. But I think the statute specifically allows it and then protects it unless it's brought up by the defense first.
I get you on the statute. Where's the due process clause on that? Because just because the Texas legislature passed a statute doesn't mean it's automatically a priori
Thank you. I like him.
constitutional.
I mean, I don't.
Take a look at his face. Let me get this sparkle off of there. Hang on just a second. I want you to take a good look at his face. Because right now, he is like, I don't want to hear this. We've talked about this over and over, and you're stretching it. I think he's already made up his mind. I like him. Here we go.
I suppose someone might argue that the text of the statute gives enough notice that if you raise an insanity defense later, that this conversation could be used. But now we're all counting on the accuracy of the written report from the expert. There's no video of this event. Defense counsel's not present because he thinks it's about competency. And I guess the point is, well, he should have known there's a risk because the statute informed him of that.
Right. I mean, I think that's true. Did I answer your question? I apologize. I wanted to come back to that because I wasn't sure if I answered the question.
This is exactly why every one of these should be videotaped, every single one of them. And if you're going to show it, in the trial, you need to make clear. And the reason why they don't is because of this happening right here, because of the things being held against you. If you said this on videotape and it showed in the trial, is the jury going to hold it against you? Of course they are, right? So I think that's why they don't videotape it. But the flip of the coin is, if it was videotaped, then you would have clear discussion right there. There would be no question about what was and what wasn't. And I really think in this case, they did not have an unbiased, neutral doctor here. Here we go.
That you were asking.
I mean, I feel like my question was half question, half comment. It just feels like once we get into the mental health arena, it's almost a civil case at this point, and everybody gets access to everything. It's sort of, I feel like we're just trapped.
Right. Well, what I can say is that if they had not presented Dr. Clayton, the state would have never presented Dr. Compton. That evidence would not have come in. That we would have only, and that's why it was offered in rebuttal. They pled not guilty by reason of insanity. So technically the issue was before the jury, but we waited specifically until Dr. Clayton testified before we put on any evidence. And even then, our presentation of Dr. Compton on direct was limited to the issues of insanity. And we did not address any topics that she talked about during competency. That was done on cross-examination. And so, I mean, I think, did you have a
No, go ahead, finish. I'm sorry.
The other thing that I wanted to point out, and we haven't talked about this yet, is that the statute does allow the same expert to do both competency and insanity. It does specifically allow for that. And so there is this, and in some situations, the expert will go in and they'll do competency first and then do insanity all in one proceeding. And so again, they're going to necessarily get information that would be relevant to both competency and insanity during that evaluation. And I think that's the purpose of the statute, is to protect that information so that it can't be improperly used later.
Do you think there's a limitation? Pretend or assume that this is a violation, a Fifth Amendment violation to talk to her about the facts of the case during a competency evaluation. Is there a limitation? Is the limitation you can't use the statements, she told me that XYZ, or is there even a limitation of using those illegally obtained statements and forming an opinion? Do you think there's a distinction there?
I think that, well, again, I would of course take the position that nothing she obtained was illegal, but if we were to assume that, let's say there was something that was determined to be improper, I think that would be excluded, that we wouldn't be able to talk about that. It would have to be redacted from the report. But again, when we're in a waiver situation where the defense has presented the evidence first, I think it's all admissible under the law.
My question was, did her lawyer have full knowledge of the expert's opinion on her sanity before he decided on his trial strategy?
Yes.
That was in a report that he was able to review, and before he put his expert on the stand, he knew all of that.
Yes, the defense gave notice of insanity, and then like a short time after that, Dr. Compton went in, and then as soon as her report was sent to the state, we forwarded to the defense, and so they had notice of that. And that was about 8 months prior to trial. So that was the point at which we all knew we were going to trial, because there was a chance that if Dr. Compton found her insane, that this case was not going to trial. If she had told us that she believed she was insane, that would have been the end of it. And so we send Dr. Compton in.
But she could not do that because this doctor had already decided before she ever even spoke with this woman that she was not insane, that she was competent and sane to stand trial. So there's no way that this could have happened. Damn.
Or incompetent.
Insane. Or incompetent as well. We would have sent her for restoration. And honestly, like at the time that Dr. Clayton did initially evaluate her, I think she was incompetent, but she had been on medication for those 3 months.
She'd been restored, is what she's saying.
Who was it that first suggested that there was a need to communicate with her about competence for trial? With the state, wasn't it?
The defense.
The defendant, okay.
Dr. Clayton saw her first. They had a report from Dr. Clayton.
He's real tired of it.
And but the report, there's like very strict timelines in the competency statute. I apologize, I think I'm out of time, but may I finish my answer?
Of course, you're not out of time.
there are very strict guidelines in the competency statute about when that report has to be filed with the court. And so that time had lapsed. And that is when the prosecutor said, hey, can we send Dr. Compton in to do another competency? And at that point, she was competent. She had basically been restored in the jail. But if she had said she was incompetent, she would have gone to the state hospital for restoration, and that would have been the process. So I think it was the same thing with insanity. There is a strategic motivation for the defense to allow Dr. Compton to go in, because if she found her insane, that would have been the end of it. But then once we got her report and once we knew what the findings were, then that was the point at which everyone knew we were going to trial on insanity. And that's what happened. And that was about 8 months prior to trial. If there are no further questions by the court, the state would just ask that you affirm the Fifth Court of Appeals opinion in this case.
Thank you very much.
Of course you
Counsel,
do.
was there anything you'd like to add? You have a minute if you'd like to use it.
Just very briefly.
But before you start, counsel, one quick question. Assuming error, harmful or not, and why?
Well, the error is harmful because, again, Dr. Compton was presented very incorrectly as a disinterested expert, and that does sway, in my opinion, a jury's opinion. This case, this was a very mentally ill woman who committed a horrible act thinking that she was protecting her kids. Okay. And again, that's in my opinion, very insane. So you have an expert that comes in, retained by the state for both competency and insanity. Defense counsel is not told that she's going to be interviewed. His client's going to be interviewed by insanity. And that's why, he didn't have the option because he didn't have the knowledge of that. That's where the harm comes in, because this expert and, state counsel also had talked about, well, it doesn't matter how she was retained. Well, in volume 8 on pages 57 to 58, the state's attorney, the prosecutor, was arguing that we can rescind the order under 46C as a disinterested expert and just make her our expert. The state knew that they made a big mistake by proceeding to represent Dr. Compton, the disinterested expert. And that's where the harm comes in. If a jury hears from the court's expert, the disinterested expert, that, yep, she understood the wrongfulness of her actions, that places a big emphasis, jury places a big emphasis on that. And there's just, I would, if I hear from who I believe to be the person appointed by the court, not the hired gun of one of the parties. So this isn't a case.
Two questions there.
Sure.
They did specifically identify during that direct testimony, the rebuttal, that, okay, sometime after that you were appointed by the court. But before that, they said you had been retained by the state.
Yes.
Correct. So the jury heard that this expert was retained by the state.
Well, was that during the sub rosa hearing, the 705 hearing, or in front of the jury? Because there's a lot of testimony from Dr. Compton that was mixed.
It says it's the direct examination. The question was, okay, now can you, to clarify at that point, you had been retained by the state. Answer, correct. To do the competency evaluation, is that right? That is correct.
But during voir dire,
he's like, whoops.
when the defense counsel was asking, and this was page 243 to 244, when defense counsel was going to ask the jury about, experts being hired by one party or appointed by the court, the state objected, and they approached, and counsel for the state wasn't allowed to ask that question. So the jury was picked based on the understanding that Dr. Compton was a disinterested expert.
I have one, I know you're almost out of time. I have one question I think that you can do with a very brief answer.
Sure.
If I read it correct, and I could be wrong, so correct me, but the Court of Appeals did a 44-2B analysis, right? If we find that the Fifth Amendment is preserved, do we send it back for a 44-2A analysis?
Excellent question. I'm of the opinion that this court can make the decision that this is a 44-A error. 9 very able judges that can do that. I don't think it needs to be sent back.
That's a legal question, isn't it?
Huh?
That's a legal question, right? We would review it de novo anyway. Right?
Yeah. I think it'd be resolved right now by the court instead of just staying.
Okay, counsel, why don't you take about another 30 seconds or so? If there's anything you think we haven't heard that we need to hear, if you could.
No, Your Honor. I think we got to the point of the matter pretty clearly.
Any further questions? Okay, I'd like to thank both counsel very much for your
There you
arguments
go.
here today.
There you
This is
go.
The only case we'll take under submission. This case is now under submission, and we will stand in recess until such time as we can.
Okay. Now, stop sharing my screen right there, and we'll talk about this for a minute. And then tomorrow, let me get this off of here so we can actually, you don't have to look at all the sprinkles right there. But tomorrow we're actually going to read the brief. Now, remember he talked about in volume 8, page blah blah. There's many volumes of this case. There's a lot of information. It's been through back and forth several times. So we're going to read the brief tomorrow, and it may take us 2 times to finish the brief because it's big. And it's got a lot of questions because of the situation with this doctor who should have never been allowed to testify, period. And yes, I understand that the defense opened the door for this testimony to come in. Remember, this is talked about in Lori Vallow's trial too, about they would not bring in certain things under Rule 404B, but if the defense opened the door, they were able to bring it in, right? Remember that scenario? Well, it's kind of the same thing, but it's about the expert's testimony and the expert's preconceived notion that she was absolutely sane before she ever even spoke to her. So that's what's going on here. We'll come back on it tomorrow. We're going to read the brief. I just wanted to come out today and just give you a little information about what this case is about, how it started, and what is going to be the appeal, why it's being appealed, on what basis, and then tomorrow we'll discuss what was the actual opinion, because it's absolutely out. That is why I picked this case to talk about, because the opinion is now out. Anyway, you all have a wonderful afternoon. Take care of yourself out there. I always say, go hug your babies. Life is short. It's even shorter. Your time with them is even shorter. I always talk about my hard time being an empty nester. And yeah, I had lunch with him yesterday. It was fun. I went and cleaned my little baby's house yesterday and had lunch with him. And it was fun. It was nice. But anyway, you all take care. We'll see y'all guys later. Questions, comments, whatever you need to, please hit the thumbs up. Either you don't. If you don't like it, it's okay too. We understand. We understand that this channel is not for everybody, but I think it's fun to hear every part of a trial from start to finish, and the absolute ending when the appeals court says yes or no. Okay. Anyway, I'll see you guys later. Have a good evening out there. Thanks a bunch. Bye.